Ladies and gentlemen of the jury, I direct you to strike that witness's testimony. Why would a judge say that to a jury during a trial in New York? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. I have a few moments to share this great information with you. I'm at a seminar today, and now you're at trial, and now we have a witness on the stand. During the course of questioning, the defense attorney raises an objection and says, "Your Honor, this witness isn't qualified. This witness is not able to testify." And now the judge turns around and says, "No, I'm going to allow this witness to testify, subject to learning more of this witness's qualifications." So now we have lots of questions. The defense attorney gets up and starts cross-examining the doctor, and now it turns out that this doctor is not qualified to testify. And at the end of that cross-examination, the defense attorney is going to turn to the judge and say, "Your Honor, at this point, I ask you to strike this witness's testimony because he's clearly not qualified." Now, when a doctor is not qualified, the judge will usually make a ruling that says, listen, that goes to the weight of the evidence of what this doctor is talking about. But as far as admissibility, letting the jury decide whether or not to listen to this, in most instances, the judge is going to allow the jury to hear it and then have them come to their own conclusions about whether or not this doctor was credible. There are some instances where the doctor has done something that now the judge is going to turn around and tell the jury, "Ladies and gentlemen, you've just heard this doctor testify. Based upon my legal ruling, you are to disregard this doctor's entire testimony." And what does that mean? It means they cannot consider the questions, they cannot consider the answers, they cannot consider anything this witness has said as evidence when they go back to deliberate to decide who's more likely right than wrong. Who do they believe? Who don't they believe? So why do I share this great information with you today? I share it with you because this does come up quite often, where the defense attorney tries to get an entire witness's testimony stricken from the record so that the jury cannot use that as evidence to come to their conclusion. You know, in all likelihood, you're watching this because you do have questions. Questions about your matter that happened in New York. And if you do have legal questions, one of the things I recommend you do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a fantastic day.